matters of this moment calls for deep application of mind, considerations, and bestowal of thoughts which will fit with the level of debates. So I try to visit and revisit again and again so that as far as assistance to the court is concerned, there's nothing is wanting. But few broad thoughts I thought I'll share with the Lordship before we get into the nitty-gritties of what
Tell us one thing only.
Your Lordship, please.
If we see 324(2), it says subject to the provisions of any law made by the Parliament. Subject to the provisions of any law made by the Parliament.
Your Lordship, please.
Our request is, please take instructions and inform. Either there was no necessity to frame any law on the subject, or it was never brought to notice that some law is required for the purpose of implementing clause 2.
Your Lordship, please.
Which calls upon the authorities to make an appointment to the Chief Election Commission.
Right.
Because we are now 76 years down the line.
Your Lordship's right.
And merely because somebody knocks the doors of this court and call upon to examine the issue, then only you come out and say that we'll examine as to what is to be done on our part. And why your obligation cast by the constitution makers has not been so far acted upon.
I will try to address that question. And
because the judgment which you are citing, Vineet Narayan and all, there was no legislation, and this court thought some legislation is required on the subject. For which the Parliament, in the ordinary course of business, has to take a call. Anyhow, as per the social structure changes, law also required to be.
Absolutely, no doubt about it.
But in this peculiar matter, there was already an obligation where the constitution makers put on that please make the law on the subject for proper implementation and if giving effect to 324(2) by making an appointment.
That's one way of looking at whether the constitution itself casts an obligation. And the question arises at what point of time?
What is your stand?
What will be?
You are not required?
No, I'll address that question. I first
straight away.
Lay down.
According to you, is not required, or if the court will call upon, you will go ahead.
No, either way, I don't think this question, with great respect, can be answered either or way. So let me try to explain why I take that stand, and then presently, probably depending upon the discussions we have in this matter, we try to proceed further.
All right.
Now, let me try to, because this issue, like in several other earlier situations cited before the court, are broadly built on principles of a vacuum or a silence or a gap. Way back in 1948, Michael Foley's book on the silence of constitutions has been the subject of some discussion at some point of time. Before I take your lordship into that, I just want to reflect on how one may look at that. Under that very inviting literature by Professor Lawrence Tribe on the invisible constitution again, has also triggered a lot of debates both in US and outside. So today, we are certainly, while talking about and expounding the constitution, ever since you just Marshall talked about it. One important thing which comes to your mind while screening the whole developments taking place in the past 2-3 decades across the globe in different constitutional courts, post-World War, importance of human rights, and ensuring that fundamental rights get their best possible comprehension and understanding, protection, promotion, etc. So almost across courts in Asia, courts in Europe, there is some movement towards ensuring that the courts play an important role. So therefore, today we have a lot of literature which say constitutional courts as mediators, constitutional court as positive lawmakers. So we have all those interesting literature which scans the role played by the constitutional courts across the world. But besides all that, while all that is very important, because if the courts do not play a role, then perhaps if the salt do salt, who else will do it? That's how it is. But while it is said so, some fundamental principles will also be always kept in mind. I mean, I am not going back to a doctrinaire Montesquieu theory of separation of powers. I think that is a line. That's a line which the court will move very wisely from time to time. Where it is needed, well, move it wisely. Where it is not needed, the deference principle will certainly apply. And when I say that, I don't say the deference principle will mechanically apply with a closed mind merely because the state calls for a deference. Just as you said, we are expounding the Constitution at a given point of time. Very simple example in any book on interpretations I choose, the word telegram. So did not contemplate telephone. So you said telephone would be included in telegram. Many pedestrian examples. So when you come to a constitutional meaning, of course, they stand at a very higher level. Some commentators say the constitutional courts are not merely adjudicating. Adjudication relates to pleadings, proof, evidence, evaluation of evidence, etc. We slightly stand on a different level. That's why some people would prefer to use deliberation. Again, after the Canadian Charter, people began to write on the deliberations as the interplay between the court and the state. So these are all theories which have now grown around the role of the constitutional courts. But what would probably come to the court's mind at any given instance is, how do we really merge them all together and have a manageable standard which the court will be able to deal with? And then the demand from the state that you have an obligation which is clearly visible either from the plain reading of a statute or a constitutional provision. And I don't find any explanation why the obligation has not been discharged. And therefore, we call an explanation from you and find out how it can be taken further. Or where that obligation is not cast in so many, plain words. Sometimes the court may not try to read an obligation into it, except, for instance, like the Julius versus Bishop of Oxford, power coupled with duty. So in all those circumstances, the court will say, is there really an obligation? And if there's an obligation, which Constitution contemplates, what kind of an obligation it is, when will it be triggered, at the trigger point being reached, or if it has not been reached, then how will the court look at it? I thought I'll just flag all these broad statements and propositions before I come to 324. So let me just quickly take your lordship through this. And before that, I was...
Mr. Attorney, you accept that court has a role to play in cases where there are, okay, I wouldn't call it word, we would call it gaps. There are a scope of interpretation of constitutional provisions as regards the obligation of the state.
Yes, let me only...
So jurisdiction of the court you are accepting.
Let me only...
Now we are discussing only the contours or the outer limit of that jurisdiction in the facts of the given case.
Right. I just want to qualify this gaps and silences theory. I'll come to it a little later. I'm going to expound on that.
One more thing. You must have realized the obligation. But for that, now where is the question of constituting a committee, that is Goswami committee? So having constituted it based on a meeting which was held on 9/1/19,
no.
That was constituted for this purpose, to study. So you know that an obligation is there. But it was constituted.
I'll try to respond to this question.
Have a study on it.
I'll try to respond to this question. Let me go in some... I'll make a note of each one of the questions and come in a seriatim.
Yes.
Attorney General, I just wanted to
Your Lordship,
bring two aspects.
Your Lordship.
Thanks to Wikipedia over the weekend, we just keep this. Just a phenomenon which I wanted to elicit your. You'll give a copy to. One copy to this. If just keep that's for all of you together. It's just what we just sort of found out a little bit of sort of statistics. Now, the first the chief election commissioner was Sukumar Singh.
Yes, sir.
Now he was of course a civil servant. Now the total period since Ashok Sen, in fact, brother of Ashok Sen, the Singh. Now the total period that he had was 8 years and 273 days. And the next one was incidentally the first law secretary, KVK Sundaram. He had 8 years and 284 days. Now, he was a very distinguished man, principal author of the white paper, which was used to guide India into states. Then came SP Sen Sir Verma. We don't have information, but he had nearly 4 years. I think it's about 4 years. Then came Dr. Nagendra Singh, I mean, all known to us, who became
ICJ
president.
ICJ.
And he had, of course, 128 days, but then the shortest you will find in the 50s and 60s. Then you had T. Swaminathan. Again, he had 4 years and 10 days. He was a member of the civil service, cabinet secretary. Then you had Shatta. He was Secretary General of Third Lok Sabha. I don't know whether he was a civil servant, but I think he was very distinguished because he wrote the book on Parliamentary.
So, yes.
Very distinguished author. And then we had R.K. Trivedi, he was a civil servant, but he also had 3 years. Then we had R.V.S. Peri Shastri.
A very distinguished academician.
Very distinguished academician. We'll come to it as we turn. Now things turn out, He had 4 years and 4 months. He started his career as a teacher, I believe. We don't know whether he was a member of the Law Commission.
He was.
And then we had this temporary blip, if I may call it. We as Ramadevi. She was a politician.
I think she became a governor.
She was a governor, and then she became a AC member.
That's
Her tenure was very short-lived. She was 69 days. Then you had, of course, T.N. Session, who took over on the 11th of December, 12th of December 1990, lasted till 11th of December 1996. And we don't have to say about him. I was obviously sort of.
I just want to correct your lordships on one small thing. Ms. Ramadevi was law secretary, union law secretary. So I don't
think she was a civil servant.
Well, union law secretary is
For
what
some
the
time.
book co-authored by her says.
Was he
Yes,
a civil
he was.
servant?
I'm
Just
not
take a
sure about
Book on election laws.
Yes, book on
Just find out whether she was a civil
Yes.
servant, because Wikipedia can also be.
Yes.
The credit goes to Wikipedia. But we wanted to this for another purpose, and that's going to come.
I mean,
Yes.
And that's going to come now.
please.
M.S. Gill, he had 4 years, and that is 96. Now, please mark from now onwards. That is from 2007, February 2004. Your journey begins when the longest period is hovering around 2 years.
Yes.
You'll see 2 years. Lindo had 2 years. He was a civil servant. Yes, Krishnamurthy, he had 1 year and 69 days. B.B. Tandon had 269 days. M. Gopala Swami, he had.
He was there for quite some time.
He was there
With the Home Secretary.
He was there for 3 years.
Right.
He was there for 3 years. Then we had Naveen Chawla. He had 1 year, 89 days. Qureshi, 1 year, and I think 369 days. But 2 years, nearly 2 years, all 2 years. Now, V.S. Sampath again, 2 years. H.S. Brahma, I think it's 92 days. Then over the page, Naseem Zaidi, again 2 years. Anshul Kumar Jyoti, he had 200 days. Om Prakash Rawat had 312 days, less than a year, all less than a year. Sunil Arora, 2 years and 131 days. Sushil Chandra had 1 year and 31 days. Rajiv Kumar had 188 days. That is less than a year.
Yes.
Correct? And of course, we have the latest is Arun
Yes.
Goel, but we don't know about him.
Right.
The question is this.
Yes.
You see, under the 1991 Act, the term
Give the right.
of the Chief Election Commissioner is to be 6 years.
Or 65.
It is hedged in with a limitation following from the proviso, which says, provided, however, if he attains the age of 65 prior to the expiry of 6 years, that his term will come to an end.
Yes.
Correct? Now, what we are trying to point out to you, and we expect an answer from you, because
Yes.
this is a very, very, very disturbing trend,
Yes.
which is this, that after 2004 particularly, the slide has begun in terms of picking up those persons whom, of course, the government knows the date of birth. They know that they will never ever get anywhere near close to 6 years.
Yes.
So the term is a very highly truncated one, known from the very beginning. So in this way, this so-called independence that you sort of pay lip service to, I'm sorry for saying that,
Yes.
is completely destroyed by having this kind of a term. See, for anybody at the helm of affairs of an institution, one of the most important things is the time he gets to, do what he wants to do. So you are actually, all this happens because it is relevant how it is connected.
I see.
The appointment process is how you carry out the appointment process. Then if you have a procedure, because you have, of course, the first proviso, as far as the
Yes.
Chief Election Commissioner is concerned, to Article 324(5), which says that you can't be removed except on impeachment.
That's right.
And secondly, his conditions cannot be varied except
That's-
disadvantage. It's
that's-
a constitutional protection. But this is a protection which you can avail of, provided you have a term. Now, your term is 188 days, your term is 160. I mean, this is a trend from 2004. Be it the UPA government or be it, so I did a little maths there also. And I found that, when it is from 2004 to 2012, we take it, for 6 years, 6 chief election commissioners for a period of 8 years. Now, 6 into 6 will be 36. That is one math. The other math is, for the period after the present government took over, that is 2015 to 2022, for 7 years, you have had 8 chief election commissioners.
Actually, one of the reasons why this is
Right.
happening is that I'll tell you, Lordship, what is happening.
No, whatever is happening, we are telling you.
Something very relevant.
This
Something
this
very
is-
relevant.
This is
I
something
know.
which we have to factor in when the discussion.
I-
Yes, yes.
I look at the broader.
What they have done, my lord, what they have done after the Thursday hearing.
We know that.
Thursday hearing, I
We
mentioned.
know that. We know that. We
They
know
have
that.
hurriedly appointed a third election commissioner
seen
between
that.
Thursday and today.
We have seen that.
And-
We are conscious of that.
And
Don't say
that-
hurriedly.
But this is this is statistics which cannot be wished away, which stares at our faces, which we'll have to factor in when we, take a view either way,
I understand that. I am not.
which we are placing right
I'm
at
so,
the beginning of your
I'm
answer.
so glad you lordship put it to me. And
Now, the second aspect is,
yes.
again, we just sort of we'll give you. These are some of the laws, relating to election commission. And we thought that, we have to look closer in our neighborhood as well. We are going to England. We thought we should start with Sri Lanka, for example. And so sorry,
No, the lordships.
we have
We-
made a,
Yeah.
we just expect that you will give it back to us.
Yeah, we do.
Little
I
nicerly.
had also occasion to look in
The
the.
government property so that we.
No.
So we got one more actually, we can just. So what we've done is, if you see, the first is Sri Lanka.
Other countries. Sri Lanka.
it says, sub-article 3, it's incorporated in the Constitution, Article 103, sub-article 3. They go as far as, prohibiting. No person shall be appointed as a member of the commission or continue to hold as a member if he is or become a member of the parliament, provincial economy, local authority, or is appointed as a judicial officer or a public officer. Okay, that is one thing. Then you have Nepal. See how far they have gone. They say that at 245(2), the president shall, on the recommendation of the Constitutional Council, appoint the chief election commissioner and the election commission. So they have made that. Now let's go over to Bangladesh. There, of course, it is closely, they have this same, almost same, subject to provision. I think this modeled on our constitution, and certain restrictions are there. If you can skip it. Now let's move over to Pakistan. You see how they have structured it in terms of the criteria for appointment. No person shall be appointed commissioner unless he has been a judge of the Supreme Court, or has been a senior civil servant, or is a technocrat and is not more than 68 years. Now, they have taken pains to also articulate what is meant by a senior civil servant, a technocrat, etc. And then the Prime Minister shall, in consultation with the leader of the opposition in the National Assembly, forward 3 names for appointment to the Commissioner to a Parliamentary Committee for hearing and confirmation of any one person. And various provisions are there which we sort of commend for your consideration. Now, if you come to the next one, you'll find
UK.
UK. That is another model you'll get there. And if you come to the US, the last one, the Federal Election Commission, so it goes in for the Senate confirmation. And there you see at the 3, Arabic 3, members shall be chosen on the basis of their experience, integrity, impartiality, good judgment, and member, etc., etc. And various other restrictions are put. So we just thought that we should place this for your consideration. You want us to remain behind other countries, particularly having regard to the disturbing trend we found, how it has become a license, how they think there are no checks and balances. Nobody can question them because there is no law. There is nothing is like you said. We are talking about the silences of the Constitution.
I see that.
How the silences of the Constitution are being exploited. There is no law, like you said. I mean, there is no law. There is no check. Nothing can be done legally. Yes, they are right.
I think just first blush, having seen these, every one of these constitutions mentions mandatory using the term of the chief election commissioner and election commissioner. It also provides for removal to be on par for both the CEC as well as the election commissioner. I just saw it. I mean, we're very grateful for this level of research done, which we could have done.
Not on the lexical meaning of may or shall. It depends on the context in which it is used, and then how an authority perceives the nature of the duty. Therefore, we did not go on those lines. I've also seen many of these.
You would have seen it
to many of this
wanted to
constitution
just place it.
and for instance, the Canadian electoral form.
That's right.
The Constitutional Assembly had looked into that. So, at some broad and except this very detailed, I've also
one more last observation so that you can just think of it when you reply. See, in the Constitutional Assembly debate, you notice actually the tide was turned by the member from Bombay. His name, I forget the name. He would say that the Election Commission is contemplated as an agent, as a part of the government.
correct.
And what is his name?
I'll just pick it up.
Munshi came in. So Professor Munshi remarks, he said, let there be a law, let it be worked out. And it can be a part of the government. It should not be divorced entirely. It can't be given independence because all the men, the resources are being provided by the state. So it is necessarily dependent upon the state.
Yes, yes.
It cannot have an independent role. He goes to even say it cannot become a super government.
Yes.
So those, the point is at the time when the founding fathers, because when you talk about expounding the constitution, as you know, there are 4 theories.
Right.
Which the US Constitution, the originalist theory, which is what the founding fathers had in their minds at that time. And, future generations are hidebound, they can't go behind it.
Yes.
Whether we should stick to the originalist theory, which is what some judges in the US Supreme Court, advocate, but whether we should do that in conditions peculiar to our country and knowing how things are, power when it is obtained, how it is used.
I know they'll always
2004 to 2020, I've given you statistics.
Yeah, like, absolutely. There'll always be a perspective from that point of view.
That's
What,
right. The point
Peculiar.
is,
That's right.
we have to deal with our conditions.
That's right.
Our men.
That's right. And while we enter into that,
Sorry, I mean, we have taken.
no, certainly, I'm extremely grateful
So
for
that
inviting me, and I've also done some little exercise, but not fully as you lordships have done. I called for some information and then looked into it, and one may throw some light on it. After probably I'll get some more instructions on this, how to help
Go ahead.
lordships. But before I broadly looking at pre-1991 and post-1991 can be broadly classified. Why it might have happened like this is too difficult to guess. But then probably one has to dig into the archives, what happened 8 years, long years. But now that the law is there after 1991, how do you go about working under the law 6 years? Whether it is obligatory, can you curtail it? Will you not look into it more closely and say, yes, I am bound by it? All those questions are very important. And certainly one cannot shy away from those questions.
Yeah.
I'll try to, but broadly speaking, when I looked into this, my first question was, what is the position in other countries? So I tried to look into it. If the constitutions in other countries, if the constitutions themselves proceeded on certain lines, then we are talking about a constitutional scheme. So a comparison between 2 constitutional schemes may or may not be too appropriate, except where distinct constitutional schemes notwithstanding, the working under these constitutional schemes are given some lessons useful, which can be borrowed. That's how I look at it. But instead of getting into those very narrow dividing lines. But if the Constitution of India says 324B shall be like this, and it also provides a certain understanding that over a period of time, whenever the time may come, Parliament may enact a law to deal with certain matters or subjects under 324B 1, 2, 3, etc. Then the question that may arise for consideration is whether the Parliament has done something under the Constitution is one question. Whether the other parts of 324 1 to be the place of the President, how the President will exercise her or his discretion, pointing, so and so, they are parts of the Constitution. It is one well-settled principle that an original provision of the Constitution cannot be put to challenge. And Electoral Prashant Bhushan in his submission says, declare the appointment procedure as unconstitutional. Court will not do that. An amendment to the Constitution because of 368 powers, all those basic structure, of course, that will certainly be a matter for consideration. Therefore, a very important distinction in an original provision of the Constitution, as it stands, the court will not strike it down. But where it becomes necessary, that's why in the context of fundamental rights, well, let me put it like this. We keep saying fundamental rights are an integral part of the Constitution. Part 3 and Part 4 are the 2 chariots, the wheels of the chariot and the constraint, etc. But I suppose if fundamental rights permeate the entire constitutional scheme, let us proceed on that footing, so that we have a very comprehensive view of the Constitution itself. Today, courtesy after 1978, state of Karnataka, Rajasthan, all those Bommai has taken the leap forward. And there are even in Article 311C, the President's decision-making process in respect of armed forces can also be subject to scrutiny. So what are those matters that are open to scrutiny are all on the basis of fundamental rights and certain scheme of the Constitution which will advance the fair movement of the Constitution towards a higher social order. That's how one can look at it. But that would again not mean that by process of interpretation or a meaning given to words in the Constitution, one can enhance the quality of the working of the Constitution, raise it to higher levels of working. That is done. But to come back when, if the original provision of a Constitution has certain issues, then will it not be a matter for a parliamentary debate? Will not be a matter for a broader social democratic debate as to whether this provision should remain as it is? So that line of distinction, I think, is very important. So that's why I would like to answer both these questions a little later. Now, I was reading a book on administrative law in US. A very interesting observation. When I tried to read it and then go further with my silence of the Constitution.
Yes.
This is how the author puts it. I tried to kind of paraphrase it. The subtle problems of modern policy making are more akin to automobile design. I'll take a printout and give it out. The subtle problems of modern policy making are more akin to automobile design or composition of a symphony. It's not that. No, I'm not reading it. I'm just reading it from my hand. I'll just give it to you. I'll just hand it over.
What is the nature of what is the book?
It's a administrative law by Christopher Redley. I'll hand it over.
Administrative law by, what is the name of the author? Just give us the name of the author, that's all. By Christopher
Edley.
Edley.
I thought I was paraphrasing from that particular page.
Edley. Yeah.
The subtle problems of modern policy making are more akin to automobile design or composition of a symphony. The artistry is in the complete vision and in the integration of subsidiary skills. No natural law assures that a collection of skilled musicians will produce beautiful music. And no natural law of management assures that a collection of experts will produce worthy administration. That's where all these problems arise. The whole is neither more nor less than the sum of the parts. But why I wanted to read it out is that we are looking at the design of the Constitution in certain parts where we think, is there something originally lacking in the vision, or it was not the original lack of the vision, but a later point of time in the understanding of the importance of the latent designs in the vision, and therefore there is something which is deficient in the understanding and the working of the Constitution. So if you're looking at the later part, deficiencies and in the understanding and the working of the Constitution, and therefore there is something which is wanting. That's why we all entered in the question of a vacuum gap and things like that. Probably I would like to pose a larger question. Apropos what this poster told me. We will take your lordships from Vineet Narayan onwards. And these are all areas where we are concerned with either the realization of fundamental rights have some issue, or there's some disability imposed, or the infringement is indirect. So on and so forth. One can probably multiply how, in the context of realization of fundamental rights, there is an issue. And that the court, therefore, is anxiety and concern to ensure as a sentinel on the QV that fundamental rights shall anyway, in any manner whatsoever impediment, obstacle shall be removed and shall be facilitated, realization made possible. It's in those areas where not that the court would imagine a vacuum, but there is an actual concrete situation when the court comprehends and says, yes, let me look at it and how do we handle the situation. Therefore, there's always a gap between in law and life. Holmes' famous statement is logic, experience, but Chief Justice Israel Barak said, no, it is both. It's both logic and experience. I think that's correct. So that's why you're talking about the experience and also the logic behind it. So having said that, let me just take a quickly and then go back to my. This book was written in the context of the unwritten Constitution of England. There are a lot of constitutional conventions which occupied parliamentary debates and how courts would look at you also come to page 10 of this, there is just the second paragraph. Abeyances should not be thought of. Page 10. Abeyances should not be thought of as empty constitutional gaps to be filled in through the normal course of legal interpretation and political development. Neither should they be seen as constitutional deals by which particular issues are attended through a conscious form of mutual accommodation between contending parties, nor as conventions demarcating expected behavior through informal but generally obligatory agreements. On the contrary, abeyances should be seen as akin to barely sensed disjunction lodged so deeply within Constitution that far from being susceptible to orderly compromise, they can only be assimilated by an intuitive social acquiescence in the incompleteness of a constitution, by a common reluctance to press the logic of arguments and political authority to conclusive position, and by an instinctive inhibition to objecting to what is persistently omitted from the constitutional agenda. 3 or 4 thoughts which are suggested here. The last part of it is that by a common reluctance to press the logic of argument on political authority to conclusive position, and by an instinctive inhibition to objecting to what is persistently omitted from the constitutional agenda. That's why we go back to the original constitution and we look at it as something which is taken, which is given. So it's one thing to say what the constitution says, and it's a different thing to say what the constitution means. And what the constitution means will often happen when the court is called upon to engage on, most importantly, on the rights of people. While it's certainly an important value in itself that an independent election authority is a fulcrum for free and fair elections, citizens' participation in a free and fair election, the enabling element, etc., all that is well taken. I don't think we need to have any debate on that at all. But in what context the court will be called upon to say, what is that you have failed to perceive? That's the only question that being presented. I have a 2-part note which I have prepared. I think it's been handed over to your lordships. I have been very ably assisted by Mr. Balbir Singh. We had a lot of useful insights. We had good discussions. I'm sure he will continue to assist your lordship in the best of his capacity. Before I read this note, and it's important that I try to come back on the instances of appointment, the durations, etc. I'll try to come back on that. Preferably if I get some factual data, I'll try to come back on it. I think it's very useful for the court and may I just read a few parts of this part 1 of the submission. Paragraph Roman 2 at page 2. The concerns raised by the petitioners were debated at the Constituent Assembly, which finally approved 324 as it stands today. In the Constituent Assembly debates, Dr. B.R. Ambedkar submitted with regard to the appointment of Chief Election Commissioner and Election Commission. There are two alternatives before the drafting committee. You have a permanent body with 4 or 5 election commissioners that will be making the commission a permanent body who would continue in office throughout without any break, or to confer powers on the president to appoint ad hoc body when the election will be annual. Or the two proposals consider the drafting committee steer a middle course to have permanently in office and of the chief election commissioner, leaving the conditions of the tenure and further appointments of any other election commissioner the will of the president. On the tenure of the election commissioners being made fixed and secure, Article 2, Section 2 of the US Constitution is considered, whereby certain appointments specified therein cannot be made by the president without concurrence from the Senate. Dr. Ambedkar submitted the American practice a very dilatory process and is likely to create administrative difficulties. Then, therefore, that's an important pointer to be kept in mind. If the other examples already before the Constituent Assembly, and those examples did not persuade the constitution makers to adopt them, either in the unmodified or any modified form, then probably the court will say that what way to the Constituent Assembly will have a certain amount of consideration and deference. It's one thing to say when you're debating in the parliament that what are the schemes would better serve the current needs of a society. And those parliamentary debates may travel or cover a wide range of concerns, issues, and data, whatever different political parties may come to fore in the parliamentary debates. So when therefore the Constitution as it originally enacted says, I take this course, at a very extreme point of view, I'm not, may not be seen as saying that there are certain insurmountable obstruction to the court navigating or steering constitutional surveys. I'm not saying that at all. But the extreme point of view, if the court were to say, we have some disagreements today on what the original Constituent Assembly thought about. And the disagreement may come in only in the context of experience. Experience saying that the independence of an electoral body has been mortgaged, either in the appointment process or in the removal process or in terms of conditions of service. See, if that experience is not very clearly delineated, I understand these instances may throw some light on that experience. I'm not shying away from that. But they must be so appealing enough and so disturbing the conscience of the nation and more particularly the court that this experience tells us that probably we need to have a relook, a second look as they call it. But what will the court then do? So will the court say we have on deliberations in the course of engagement with counsel and parties, assistance of parties, etc., we think that this would be a more suitable course of action. That can be a problematic issue at some point of time. Why I want to say that, I'll come to it a little later. Because we are not now talking about a standalone provision in the Constitution, a standalone isolated instance where the court may take a view, and maybe it's the most appropriate view to be taken. And therefore, it doesn't become a precedent issue at a later point of time. But when the court may proceed to issues on a certain constitutional deliberative basis, say that this is what the government should do or the parliament may do. So I look at the various provisions of the Constitution where the Constitution has provided for an obligation or a duty or the parliamentary intervention at some point of time without indicating at when they will do it. So I have large number of several instances in the Constitution where parliamentary intervention is proposed and suggested. So this may not become an isolated one-off instance, and therefore what the court may do, whatever little or minimal or whatever the court may do, may have some implications on the other aspects of Constitution where the parliamentary intervention is found desirable. I'm only looking at that point. I'm not even saying because of that you will not do that, but that will be kept in mind by the court. That will be a very important question that the court will keep in mind.
Yeah. Yeah.
The condition that they will need to speak for these. Stick to the court. Part 2 of the note.
Yeah.
The part 2 of the note is dealing with the concept of vacuum.
Part 2 of the note.
And there is an annexure A to that note.
Interfere.
Yeah. Yeah, we got it.
So I try to enumerate those other provisions of the Constitution where parliamentary intervention is looked at. Of course, the context may differ. There is some could be variations in the need, but just I've enumerated them. For instance, we have Article 10. Every person who is or deemed to be a citizen of India and any of the foregoing provisions of the part shall, subject to the provisions of any laws made Parliament, continue to be such citizens. Okay, there are many provisions where Parliament has enacted laws. So those are laws I'll try to point out where the need, the necessity, the urgency, which are probably built into the provisions themselves, is perceived by Parliament, and Parliament is proceeded to enact legislations. So therefore, it all depends on one, the context where parliamentary intervention is envisioned, and the need or the necessity is also felt by the Parliament. Parliament is enacted thereafter. So citizenship is a very important aspect of the Constitution. It must require parliamentary attention. Now, the Secretariat of Parliament, 98(2). Parliament may by law regulate the recruitment and conditions of service of persons appointed in Secretariat of Office of the Parliament. Until provisions made Parliament in a clause, so the President may, after consultation with so-and-so, make rules regulating the recruitment conditions of service to the Secretariat of Staff, the House of the People, etc. Therefore, there are rules which have been made under 98(3). We skip then Article 137.
You are not for a moment suggesting to us that members of the Secretary to the Parliament are to be compared with Chief Election Commission.
No, I'm not saying. I'm not saying. No, certainly. I'm not suggesting.
I mean, whether
I'm
you
only
make a
looking at.
law,
No, please don't
whether
mistake.
you make-
Certainly. I'm not doing that at all. I'm certainly not. I'm only trying to enumerate those provisions where
We follow.
Parliament.
It's very useful because
That's all.
we get it sort of one.
Then again, 137. Subject to the provisions of the law made by Parliament or any rules made in the Article 145. The Supreme Court shall have the power to review any judgment.
Just one.
I'm sorry, not just the court. The court.
Yes.
What I will do along with this, I'll give an additional note where Parliament either made rules or provisions or law. So that will complement. That's right. So we don't have any parliamentary law as far as the 137 power is concerned. That's been entirely regulated by rules made in the 145. But the constitution equates parliamentary law to a rules made in the 145 or rules made in the 145. They are more or less placed in the same footing, subject to the provisions of any law made by Parliament or any rules made in the Article 145. So therefore, if the rule in 145, unless the Parliament thought that there is something more to be done by the Parliament, Parliament would have enacted. If they are sufficient enough to deal with the matter, and therefore, having regard to the high position the Chief Justice occupies in the consultative process, the Supreme Court employs welfare cases thereafter. Then 142, clause 2, subject to the provisions of any law made in this behalf by the Parliament, Supreme Court shall so and so all and every power to make any order for the purpose of securing the attendance, etc. There is no law as such on this subject. Again, Article 145. Subject to the provisions of any law made by Parliament, Supreme Court may from time to time, the approval of the President make rules. So by and large, only rules made by Supreme Court under 145, there's no law made by the Parliament. Then again, 146, we have clause 2. Subject to the provisions of any law made by Parliament, the conditions of service so shall be prescribed by Chief Justice and the rules. Again, the same position, there is no law except the question of pay, condition service of Supreme Court employees came before this court on comparison with condition service of High Court employees. That's how the Supreme Court employee judgment came. Then 148, the salary and other conditions service of the Controller and Auditor General shall be such as we determine by Parliament by law, shall be as specified in the second schedule. Again, subject to the provisions of the Constitution of the law made by Parliament, conditions of service, etc., shall be such as to be prescribed the rules made by the President after consultation with the Controller Auditor General. We have rules. I may then come to Article 243K. Subject to the provisions of any law made by the legislature of a state, the conditions of service and tenure of so and so shall be such as the governor made by rule determined. Therefore, the rules made by the governor in this regard. In Article 300, Government of India may sue or be sued by the name of the Union and Government of the state, etc., subject to any provision to be made by Act of Parliament or the legislature of a state enacted by virtue of the powers conferred of the Constitution. Sue or sued in relation to respective affairs in like case of the Dominion of India and the corresponding province, the corresponding Indian state, etc. And is often cited for the purpose of vicarious liability of the state and constitutional torts and so on and so forth. Then we have all these provisions, Article 338, National Commission for Scheduled Castes, and 338A, National Commission for Scheduled Tribes and Backward Classes. They're all constitutional provisions. And every one of them, each and every one of this provision talked about subject to provisions of law made by parliaments. And there are parliamentary legislations regarding their terms of appointment and who shall be appointed. Therefore, there are instances in parliament that are enacted. I'll give those instances. Again, in Article 367, we have, for the purpose of interpretation, the Parliament can always say who is a foreign state. Then turning over to the next page, for instance, in Article 21A, these are constitutional provisions which contemplate formation of law by Parliament, each one of them. So Article 11 talks about regulating citizenship by law, there is a law. Then Article 21A, right to education, there is a law. Then Article 22, Parliament may law prescribe circumstances so and so. Preventive detention, there are legislations on preventive detention. Then 32, so of course, which Parliament has not so far done that. It's good that they have not done that. Then 33, you can skip that. Then Article 35, notwithstanding anything in this Constitution, Parliament shall have and the legislature of a state shall not have power to make laws with respect to matters which under clause of Article 16, clause of Article 32, so and so, we provide for law made by Parliament and for prescribing punishment, declared, etc. There is no state law, of course, that's forbidden. In Article 59, conditions of President's office, So the second schedule continues to operate. Then Article 70, Parliament makes such provision as it thinks it for the discharge of the functions of the President, any contingency not provided in the chapter. There are some rules issued under Article 70, and 1969, there is a very skeletal law. Then in respect of these 71, Article 71, election of Vice President, there are legislations. 75 regarding minister, the legislations and composition of council, all these where legislations have occurred. Again, for that matter, kindly turn to Article 102. It talks about disqualifications for membership. So we have provisions under the Representation of People Act providing for disqualification. There is a disqualification legislation 1959. Thereafter, a lot of amendments, and therefore law has intervened. Parliament has intervened because they're very important. The life of democracy. You don't provide disqualification, criminalization of politics, all that. We have the intervention by this court in Association of Democratic Reforms, the right to know, being read into Article 19(1)(a). Oh, Parliament has come. In Article 105, in other respects, the powers and privileges and immunities of each house, Article 105, Clause 3. Of each house of Parliament and the members and committees of each house shall be such as in time be defined by Parliament by law, and so defined shall be those that of the House and members and committee immediately before the coming into force of Section 15 of the Constitution Zones Act 1978. Lordships know that so far there is no law relating to immunities and privileges. We have debated it from 1965 onwards, the Keshav Singh. So there's no law. Very important that freedom of speech within the Parliament, outside, whether there is a complete immunity, so on and so forth, a matter of great importance. Then Article 119, regulation by law of procedure in Parliament in relation to financial business. Article 120, language abuse in Parliament. Why I may skip some of this provision. And you come to a provision like Article 239AA. So this is a field which is now occupied by law. And so the reason is that territorial distinctions, state reorganizations, etc., are again matters of great importance for the federal structure of the country. And Article 267 relating to contingency fund, or just ahead of it, Article 262, interstate rivers or river valleys. We have a law relating to that, 1967. So an important, again, a federal issue and sharing of waters. And despite the Interstate River Water Disputes Act, we still have interstate river issues and commissions after commissions. And so these are examples where, having regard to a wide range of constitutional considerations and importance, Parliament has enacted and intervened. And some of those provisions may have some bearing on giving effect to the directive principles of state policy and so on and so forth. Let me take your lordships through my part 2 of the note and then try to find out which is the best possible way of understanding the very important issues, and may I read it?
Yeah.
When an instrument of law is unable to serve its intended purpose, either on account of defects in its operation, enforcement, or implementation, or due to its purpose not being realized, it may be said there is a vacuum in the law. In the event that such a vacuum exists, and this Honorable Court, when engaged in dealing with specific instances of this issue, also finds that the intended purpose of the law is not being realized, it may, in furtherance of the principle of enabling the realization of such purpose, embark upon the exercise of engrafting principles which may advance the same. This is different from the instances where no operational or functional deficiencies are demonstrated, but aspirational statements or an idealized situation which will meet that aspiration is set forth before this honorable court. The later categories of instances are ones that will preeminently call for political and parliamentary debate, whose outcome will be the creation of substantive legal norms or changes in the existing legal norms. This second category will not be a case of a vacuum to be filled. Interpretation of constitutional provisions towards effectuating enjoyment of fundamental rights is different from changing the text of the constitutional provision itself. In other words, such interpretative exercise will not and cannot enter into the domain of making substantive normative provisions in the Constitution. In this way, it ought to be noted that the directives issued in Vineet Narayan were nothing beyond judicial approval of the recommendation made by the Independent Review Committee. These recommendations came to be approved of the Honorable Court as worthy of acceptance towards effective functioning of the concerned investigation agencies. The use of the word vacuum in paragraph number 14 of the judgment must be therefore seen with reference to proposition number 1 above. Similarly, Vishaka was an instance of a complete absence of a relevant legal protective framework towards safeguarding the concerns of women at workplaces. The issues relating to protection of women at workplaces, having been addressed in international legal instruments, this Honorable Court has persuaded treats its legal instrument as a guiding and relevant factor for enacting domestic legal framework. The question in that case did not involve altering any existing constitutional or legal principles occupying the field. A comparison with Article 105 relating to the powers, privileges, and immunities of each of the Parliament may also be illustrative in this regard. Questions relating to the scope of powers, privileges, and immunities have arisen a number of times and have also been considered by the Supreme Court in the following cases. Now, under Clause 3 of Article 105, Parliament has been conferred with authority to define powers, privileges, and immunities of each House of Parliament. However, Parliament has chosen not to make any enactment in this regard thus far. In considering the issue, namely in the context of an argument regarding the power having been conferred on the Parliament and not having been exercised so far, this Honorable Court in Rajaram Pal so and so observed under. Similarly, if Article 1053 provides for the power of expulsion, though not so expressly mentioned, it cannot be said that a specific law in public interest is required. Simply because Parliament is given the power to make a law on the subject, is no reason to say that a law has to be mandatorily passed, and the Constitution itself provides that all the power of the House of Commons until such law is made. Thus, it is seen that even in the matter of such importance and relevance to both freedom of speech and also the powers, privileges, and immunity, the Honorable Court does not consider a non-enactment of a law by Parliament as a vacuum or a gap to be remedied by a writ of mandamus. Similarly, in several other provisions of the Constitution, the Parliament has been conferred the power to make laws.
This is very important what you have.
Yes.
This is the thing which is very important. You read on, yes.
Yes. However, the context, relevance, and the demand, etc., under those provisions vary greatly, and there can be no general proposition that in all such circumstances, the lack of an enactment by Parliament will be understood as a vacuum or a gap. That's a very important submission. I thought your Lordship will consider.
Very fair on your part.
What is being canvassed is we say because there is an aspirational provision or an ideal situation to be attained, may be good enough. Therefore, imagine there is a vacuum because this is not there in position. Imagine a vacuum and then try to fill that vacuum. So that's why I thought it's important to look at the other scheme of the Constitution where you can't say simply there is a lack or a vacuum or a gap merely because Parliament has not enacted. So the wide range of considerations, policy, etc., will enter into the domain of decision-making process. While I say that great amount of responsibility, I don't want to be taken to mean that merely because it is so in other parts of the Constitution, certain very important schema of the Constitution will require special attention. And I say, no, you must close your eyes to that. But the reason is that you'll probably be very slow and find out whether how do we really enter into the debate is the first question to be seen. So after the court enters into a debate and finds there's a room for a debate, then what the court will do, can do, or may do will be a second part of it. But the two are integrally connected. The petitioners herein place reliance on the 255th Law Commission report, dated 12/3/2015, the Dinesh Goswami report 1990, the report of the National Commission to review the working of the Constitution, and the report of the Administrative Reforms Commission, January 2007. These reports are essentially based on comparison with schemes relating to election bodies in different countries. The recommendations contained in the reports are not premised on any concrete set of facts, throwing doubt or concern as regards the working of Article 324(2). At best, these reports can be said to be aspirational and not critical of the current system obtaining under Article 324(2). Respectfully submitted, there are important conceptual differences between functional or operational vacuums in a statute, which may require remedial measures and intervention, and an aspirational or ideal situation. Even in the case of functional or operational vacuum, well, the court will not always proceed to issue binding directions for enactment of a law or a rule or a scheme. It will be all the more so in the case of mere aspirational provisions. Article 324(2) does not contemplate that a law will have to be necessarily made to replace the system of appointment prevailing thereunder. The addition or insertion of a collegium structure in Article 324(2) will be a constitutional amendment. It will have to be in substitution of Article 74 of the Constitution, which provides that the President shall act under the aid and advice of the Council of Ministers. Such constitutional amendments, which are to be deliberated through parliamentary debate and intervention, cannot be subject for issuance of a writ of mandamus. The range of instances in respect to the Honorable Court has exercised the enforcement authority for fundamental rights under Article 32 are clearly distinguishable. Besides the fact that those cases are matters involving direct infringement of fundamental rights by reason of functional or operational deficiencies or gaps in the relevant law, or being cases wherein the enjoyment of fundamental right is not facilitated or enabled due to lack of a requisite legal instrument. In all other circumstances, this Honorable Court has declined to invoke the power of authority of mandamus. The Honorable Court has also declined either to issue a writ of mandamus or to command the enactment of a law where the statutory or constitutional provision in questions are of an enabling character. The University of Kerala, so and so, this a division between the Honorable Court framed the following questions for being referred to a larger bench. Whether the court, by an interim order dated so and so, can validly direct implementation of the Lingdo Committee report. Whether the order dated so and so really amounts to judicial legislation. Whether under the Constitution the judiciary can legislate, and if so, what is the permissible limits of judicial legislation? Will judicial legislation not violate the principle of separation of powers broadly enshrined by the Constitution? Judiciary can legislate in the opinion there is a pressing social problem of public interest, or it can only make a recommendation to the legislature or authority concerned with connection. The Article 19 once here, fundamental rights are being violated when restrictions are being placed on the implementation of the Lingdo Committee report with an authority of law. And what is the scope of Articles 141 and 142 of the Constitution? Do they permit the judiciary to legislate and perform the functions of the executive wing of the state? On a reference of being, such a reference being made, a bench of three honorable judges, while not entering into the question frame, observed as under. Submitted behalf of the parties that acting on the recommendation so and so, so and so. Elections the students in are being held in their action according therewith. When the instant matter is called for hearing today, it was submitted behalf of the parties. Elections are presently being held in terms of so and so, etc. No issues, live issues survives the scrutiny of the court. In the view of the matter, we feel expedient to leave the issue at that for the present to be examined in future in an appropriate case with the occasion so arises. I just want to flag it so that this, that's right. In the instances that the Constitution prescribes that the Parliament has the power to make a law, it can be for a variety of needs and circumstances. Therefore, merely because the parliamentary intervention is suggested in a provision, does not mean that the court will interpret silence thereunder to mean that an explanation is owed to the court as to why a law has not been enacted. For the aforesaid reason, and keeping in mind the separation of powers principle, the Honorable Court will please decline to interfere in the above petition. Please come back to paragraph 10, again on the 4 reports.
Yeah.
At least I was part of these two reports, one the 255th Law Commission report and the report the National Commission to Working with the Constitution. I was involved in it. And therefore I speak with some personal knowledge. What were the perseverance which went into the making of the report? And certainly the reports were made with high purpose of ensuring that the values of the constitution shall be advanced. But I have one problem. Because today, unlike UK, the Law Commission's reports, I have a small survey of how many reports have become, translated into law. Roughly 50% of the reports have become translated into law. So 255, 100 reports, there's 124, 25 have become law. The percentage of acceptance of reports in various Commonwealth countries ranges somewhere between 40 to 50%. So it seems to the position almost in all the Commonwealth countries. In Australia, again, the problem was different because issues like abortion, pregnancy, and certain other racial issues, that native tribes issues. So again, there has been a heated debate as to how do you accept certain reports, except through a parliamentary debate. So there is a convention now in UK. There's a protocol. Under this protocol, a Law Commission report of the United Kingdom is placed before the Parliament, and the Parliament then looks into it, and an action taken report is called for on the basis of that, then the government tries to proceed thereafter. We don't have that kind of a mechanism. Therefore, in the absence of a connect between the Parliament and the Law Commission reports, so if the court were to say, we find wisdom in the Law Commission reports, and therefore they should be considered for acceptance, that may invite a certain constraint on the government, and which Law Commission report should I accept or consideration. Therefore, there can be a possibility. The court says in this, yes, consider that. So that can again become a matter for repeated judicial intervention, that every Law Commission report will have to become a part of the law. Therefore, that important area where social, political, and other considerations which may enter into executive decision-making, parliamentary intervention, parliamentary application, all that perhaps should be left as flexible as possible.
Attorney General,
Your Lordship.
if I may just,
And
you referred to various provisions of the Constitution,
Your Lordship.
where, as enacted by the Parliament,
Your Lordship.
that expression finds space. And you have also brought in the context of what you are now submitting, about the Law Commission reports and the Goswami Commission reports, that functional and operational vacuum. These are the words that you have used.
Your Lordship.
Now, if you revert back to Article 324,
And then
324.
324.
Now, here, what is the Election Commission expected to do? Superintendence, direction, control, preparation of electoral rolls, conduct of all elections, parliament, legislature, everything. So these are the various functions which are noted in sub-article 1. Now, Election Commission shall consist of these people. That is the other thing. Now, if that would have been the intention, was there any need subject to the provisions of any law made on that behalf by the Parliament? If that was not there, you would know that these are the functions to be done by the Election Commission. So somebody may be an outstanding cricketer. Your AG has been a cricketer of some repute. Somebody may be a great artist or a theatre person, but he may not be suitable for becoming an Election Commission member.
Right.
So therefore, perhaps the constitution makers intended that we need to have a legislation in place which will give an indication. And if you look at the election commissioners that you have appointed, they're all former bureaucrats. Obviously, they have a great deal of experience of how elections are conducted. Perhaps all of them have been at some point of time election officers as a district magistrate, etc.
Possibly.
Correct.
I can.
So therefore, you will not have a particular category of people coming into the domain of election commission. So therefore, giving analogy of other articles of the Constitution where they say as law made by the Parliament may not have much bearing on particularly the functional and operational vacuum aspect that you are trying to draw attention of the court to.
Yes.
So we'd just like you to keep that in mind,
Okay.
because a lot of your submissions so far is with reference to provisions where we are having a situation that there may not be. I mean, the Article 142, I mean, the courts, they do their business as maybe, what is the expression, Article 142, it is there.
For doing complete justice in a cause or a matter.
That's right. So therefore, and who are these supposed to be doing? The judges are supposed to be doing. and they're expected to know, right? So
Without-
even if there is no, I mean, at least presume to know, let us take it that way, give us the benefit of that doubt. So therefore, the analogy that you are trying to draw before us,
I try to explain.
you just keep that in
I
mind.
keep it in
That's
mind
all.
and try to explain, because first I thought it's important for us to know an overview.
No, overview
An
is
overview
important.
is
Overview
important
is
because
important.
we look at it in isolation, perhaps we don't get the total picture. We must have a total picture. So while getting a total picture, my idea was not to say that there is a mechanical mirror, view between these provisions and 324. I'm not saying that. Having regard to wider range of functions and needs and demands under the scheme of the Constitution, the Constitution makers thought Parliament will always at some point of time intervene and make a law in order that the subject is governed by a positive law. So a positive law will be made by Parliament, and thereafter the Parliament's application of mind and the desirability of making a law, the contours of a law, the principles of the law, all that will be a matter of parliamentary debate. Therefore, different needs, different compulsions, different circumstances. So when it comes to article, therefore when you apply a same yardstick, can you apply a same yardstick? Wherever Parliament has called upon to make a law, you will say there is a compulsive need which can be commanded by a judicial intervention saying, I ask you to command, I obey this. So that
We are not
kind of
asking
inflexible.
a judicial, you said that we should do it slowly. And we know you have a flair for literature. They say that make haste slowly. But 72 years,
I see that. The 72 years is something
so
which is
slowly, yes. But
which has
make
to be-
haste slowly.
I understand. I wouldn't say no to that. A 75 years, 72 years is just again another very important, let's say, a milestone. We look at it. Even in political rhetoric or political debates, you look at a 75-year-old republic compared to a 300-year-old republic of the US. So you have 300 years of learning lessons and then the Constitution. We are a young republic, but still we have learned a lot of lessons. Good enough for the short period.
Our democracy is much stronger.
That's right.
The black people in America, they got the right to vote only, how many
Absolutely.
years? 50s.
Absolutely. For instance, it took, even after Brown versus Board of Education,
That's right.
1954, it took more than 30 years before that law can be really implemented. And on the lighter side, while traveling to New York and going to the airport, the cab driver engaged me in a conversation, asked me who you are, and said, I'm so-and-so practicing so-and-so. He said, our Supreme Court in Brown versus Board of Education. And I was really, impressed by a cab driver talking to me in constitutional language.
Could be an Indian.
That is the
Could be an Indian cab driver.
So why I wanted to see this, the total picture must be before the court. And how do you draw lessons from this total picture and then the context in which the court may enter into a debate, I thought it was important for the court. That's the only reason I read it. Keep copies. Yes, I complete. So I was at paragraph 10 about those law commission reports and the commission reports. So again, we need a framework of thought or an idea or proposition in the context of which the court may say, I choose this report because of its weighty persuasions. And this report therefore deserves acceptance, and I therefore commend to you to accept this report. I have one question, whether the court would then enter into the question of the persuasions in a commission's report and say, yes, they're worthy of acceptance, and then say, yes, they're not only worthy of acceptance, but they also, I ask of you to translate it into a legal framework. Where will that kind of a constitutional survey disposition will enter? But so I said, there are a number of circumstances when legal reforms will require deep engagement of both at the societal level, at the democratic level, and the parliamentary level. I'm not saying this is an issue which I'm not saying that, but don't look into it. But I'm only trying to flag that so that
To be done carefully.
That's right. That's all.
whatever we do, to tread carefully.
I'm saying don't do it.
Come for debate before the court
No, it is.
on personal laws and.
The
Oh,
point is,
I'm sorry.
ultimately, the core issue
Your
that's
Lordship.
going to emerge, as we perhaps think, is that what is the value that we attach to many of the core issues, I mean, core fundamental principles which are
Yes,
with
yes.
our body politics. The first is that we are a democracy. At the core of democracy is the holding of periodical elections. Now, Article 19(1)(a) gives a fundamental right to citizens to express their views by choosing candidates of their choice. The purity and transparency of the elections are intricately intertwined with
Absolutely,
democracy.
absolutely.
So democracy has been held in Indira Nehru Gandhi to be a part of the basic feature. So these are all not matters which, as you very correctly say, admit of simplistic solutions. But that should not prevent the court from wading through fairly convoluted set of web of issues and finally find light, if there is light,
You're like, absolutely, you're right.
and find out if there is a way to deal with which is the next important thing. Because you took us through a number of constitutional provisions. The importance, as you very correctly pointed out in one of the paragraphs, will depend on the context. Now, here we are dealing with the context. You must recall that in the Constituent Assembly debates, Dr. Ambedkar, with the usual prescience that he had, he said this is going to be the biggest headache for the future generations, this article. So he foresaw that this is going to happen, and it's happening in our court today, unfortunately, or fortunately,
Yes.
whatever way it is.
Yes, yes, yes.
So which is that you have to deal with this issue. So after 70 years of working of our constitution, we have given you the realities on the ground, which is the way in which consecutive governments have appointed chief election commissioners, knowing fully well. See, the whole point is finally what? So finally, each party which comes to power would like to be in power, perpetuate themselves in power. So that is the whole thing. On the one hand, a party which has come to power would like to remain in power. Now the question is how that has got anything to do with the individual fundamental right. That's the issue that you're raising.
You're right.
Correct. Now what it has got to do with is the choice. Ultimately, the fundamental right consists of the real choice of the voter translating into the transformation taking place at the helm of affairs of power.
The little man with the little pencil.
Little man with a little piece of
Churchill's famous.
The difference.
Yes, yes, yes.
So we can't be, looking at it very simplistically as, it's a very complex
Yes, yes.
web of relationships.
Yes.
But the value is at the very, very core value. It's at the very root of our constitution, which is having a democratic form of government. Whether we should retain that, enhance it, or whether we should slip into, some other form, finally over a period of time. The example which we gave you was very, very disturbing because we saw from 2015 over a period of 8 years. You have how many chief election commissioners? So this is kind of, pick up somebody, give him a highly truncated office. So you are keeping him under your feet. He is doing your bidding. At least it could be said so. We are not saying that it is.
Right.
But at least it looks so. The same was the position when the UPA was in power. Each government, irrespective of the political color, wants to perpetuate itself. There's nothing wrong.
Right.
That's a right. I want to be in power. But equally, the people of India have a right to say, okay, you may have a right to be in power, but do it by maintaining the purity of the election, fairness of the election. This is, it percolates down to the exercise of the right of the individual, the citizens.
I'm only trying to
That is
find
where
that
we are
connection.
trying to tell you.
If that is live connection, that the independence of an electoral body, spreads out like the spring wheel in all directions, and each one of the spikes of the wheel makes sense for the total wheel itself. I understand that. But whether it has really happened, like for instance, we no longer have the days of booth capturing.
Pardon?
Booth capturing.
Ah.
We no longer have those days. So the days when the election commission itself, whether the state level or otherwise, was seen to be a compromise in certain election situations. Therefore, in Mahinder Singh's case, this court went into the question of the scope and amplitude of 324. And the rules or instructions the election commission can, within that 324, what it can do. Therefore, it has done several things. Parliament has enacted laws relating to voting rights and then conduct of election, registration of political parties. So many aspects of it have been occupied by rules and legislation. So the Election Commission has set up guidelines and instructions emanating from Article 324. And they virtually in the nature of a positive law, which every electoral officer will have to obey. Then where there is a disobedience, of course, there is an election petition or even sometimes writ court interferes and says that that's why even in Mahinder Singh says, if it advances the process of election, a writ court may intervene. If there is any part of the process of election. So recently, a lot of said in a case from Goa, the same proposition. Therefore, but ultimately the connection between an individual participating freely and fairly in electoral process. If there is going to be some impediment on that by reason of this, a president having the power of appointment, then one can look into it. If that connection seems to be little tenuous, or it is not demonstrated to be so clear, then certainly the court may sit back and say, is there a need? 25 years or 50 years would be a different question. But even at a 10 years point of time, the need is there, Parliament should have intervened. Therefore, that's why the connection between an individual participating in a free and fair election and the electoral body, for all practical purposes, functions as immune from any political interference. If that is guaranteed, then of course there is court intervention may not be called for. For the important
the problem. The problem is, it is one thing to say that the Chief Election Commissioner, once he is appointed, he enjoys a tenure of 6 years unless he attains the age of 65 in the midst of that term. Or that his terms of, his condition of service cannot be varied to its disadvantage after he is appointed. The first provides you 324(5). That is all very good. But there are two limitations on that. The first is the man himself. Who is the man? How do you determine? Because it's a $1 billion question, or perhaps even $1 trillion question.
Yes.
How do you search out and find out the ideal man, the best man? We are not here talking about, like you pointed out, the staff of the Parliament. Here we are talking about somebody who is given a status something close to the Supreme Court judge.
Yes.
So the Supreme Court judge makes it to this post through a very fairly elaborate process we have. Now, all of that is short-circuited by what you have under Article 324, which is the Council of Ministers. Now, if a law were to be provided, we can look at it slightly differently. Supposing the founding fathers did contemplate, there is a law because you will see from the debate that when the last speaker was Dr. Ambedkar, he said, there's a lack of time.
Yes.
And, we have to rush through. And then the amendments of Saxena, Professor Saxena was rejected. And Dr. Pandit, he also had various concerns. Both of them he did address, but then finally it is Dr. Ambedkar's amendment, what we have today, that was carried the day. So the concerns which they had, they could not have possibly, seen what is happening today on the ground. Yet they were tall men. Let us admit that. And they were imbued with the values which perhaps do not pervade society today. So many things have changed on the ground. It's a fluid situation, it's an evolving situation.
Absolutely.
If you say that generations of judges, after several years after the Constitution was framed, will be held in bondage, to what transpired at a particular point of time, and that we are prisoners and we are completely sort of helpless. It's a way of looking at it. We can only say that.
I don't think we need to visualize that.
One more thing.
Yes,
See records before us, that is the common compilation filed by them. There, the introductory part.
Which?
At page 428 onwards.
Compilation.
That is compilation 1. Volume 1. Common compilation 1.
Yes.
There it would reveal that.
Page number what?
No, it's 432. 432.
430.
It would indicate that as early as on 9/1/90, the then Prime Minister Sri Vishwanath Pratap Singh thought that the outlined electoral reforms have to be made. And that is at page 432.
Yes, yes.
And one of the most important reforms which he indicated, which are to be made, it is second one. Strengthening of the Election Commission and securing its independence. So as early as in 1990, he thought that these aspects, it requires reforms. That was in 1990. And despite the passage of about still where were we?
No,
See what is written here at
Yes.
432 on the margin side. Outlines of areas of electoral reforms indicated by Prime Minister. Then second one on the right hand side. Strengthening of the Election Commission and securing its independence. So such a reform is utmost importance. It is to be made. That was the suggestion made by the then Prime Minister. So that you realize, that is why at the outset also said, you realize that an obligation is there and you will have to take some steps. This was felt long ago, decades ago. Still, the notes and the last part of the note of part 2. There for that, the reasons given there and the last parting part of that note, it says, for the aforesaid reasons and keeping in mind the separation of powers principle, this court will be pleased to decline to interfere in the above petitions. So when you yourself thought that it is required and not having taken anything, whether still the court should remain as a mute spectator.
Yes, I'll try to respond. In the life of a nation, on very important and vital matters, either the parliament or the executive does not act uninformed. It must inform itself. And there are a variety of ways it may inform itself, like a planning process, drawing up for urban planning. It must inform itself. So for the purpose of informing itself and understanding the aspects where there is a need for executive action or a parliamentary intervention, how does it inform itself? So there are different distinct modes, and the commission of inquiry is appointed. So these are methods and means by which the information and the assessment of a situation is gathered by the executive, and then the executive thinks, yes, this must now go to parliament, it goes to the parliament. There can be situations when the executive assesses, receives information, and still either implicitly or otherwise does not either accept, or they don't accept, or they don't. In very often, it's a common practice not only in India. I find across the globe, when this kind of information process reaches the executive, how do they respond to it? There is no one set pattern by which the executive responds to an information process. It is conditioned by a wide range of political, social, and other factors. So therefore, the mere fact that information has reached in the domain of the government, probably it's easier to say, yes, what are you doing with it? It says there's an urgency in it. There's an importance involved in what are you doing with it? That question will again become a social and a political and a parliamentary debate. My only concern is that whenever there is an information on any aspect, by way of a report before the executive, will the court say, now, what are you doing with this? The problems involved in this. I'm not saying that the court will
This
not
is not
order
an
it.
information
What?
information
I'll answer.
received.
I know.
This is one of the reasons which ultimately led to the constitution of the committee.
Yeah, I only.
Going by the what is revealed from page 4.
I'm not trying to resist any resist. I'm only trying to say, how do we really look at it? Because after all, it's a dialogue between the court and the officer of the court. So I am not even trying to say what I close my mind because I have already some preconceived ideas. Let me only go on those lines. I'm not doing that. I'm only trying to say that I'm asking questions. Because of the way I think we get illicit answers which will be in the best interest of administration of justice and progress of law and rule of law, etc. That's how your lordship, so I am correct on that. Therefore, I ask myself a question: if there is an information, a survey, and a report, so at what point of time, under what circumstances will the court, if it is all his attention drawn to it, and in what framework of a proposition, the court will say that now I think, in my understanding, in our understanding, this ought to be done. That question is a very important question. So there, considerations such as any number of reports, or I find these reports are by and large talk the same language. They are a very general character, strengthening the electoral body. I can understand if there is a specific recommendation made. Say, look here, we have analyzed. For instance, if the government had to look into all these appointments, 8 years to 3 years, 150 days, something which is very wrong with the system, we must look into it. If the commission has gone into it and said it has analyzed it and said, yes, it doesn't inspire confidence in us that the system is working well, perhaps the president in her appointment process is not effectively advised with the council of ministers. Then what will the court or what other process of social debate will be initiated is the question. Therefore, I am only saying that this generality of recommendations and reports need not be necessarily a trigger point. If there is a concrete report, for instance, law commission reports are very often concrete in certain situations. Sometimes they are also very general. I've seen that. So if there is a concrete report and there is a reason made out, a good reason made out, the report, somebody will not be able to sit back and say, I don't accept it, except for political other consideration, which can be tested in a court or otherwise. Therefore, a very generality of a report, without probably not premise on certain concretization and other aspects, may or may not be a matter calling for the court's intervention, is what I was trying to say in my last paragraph. I am not saying these reports ought to be belittled. That's not what I'm putting it. The reports will have their weighty importance, certainly.
These are only for consumption.
Yeah.
They are apprising them, being the health affairs, what they thought. Make it available to us.
Yes.
Make it available for the public.
Yes.
Make it available for the parliament.
Your lordship.
Look into.
Yes.
And whatever is best possible in making a transparent system.
Your lordship, please.
In evaluating, in assessment,
yes, in
selection, lay down under the framework of rules which you have the parliament to implement. We are not, don't mistake us that we want these reports to be implemented. No, these reports are available to examine as to what should be the best modality which can be adopted in a fair mechanism, acceptable mechanism, and in upholding the this election process. And being a democratic country, we must have, I think there is no.
I quite see that.
So that is only for this purpose.
Absolutely. I mean, when
we may examine all the reports, but may not agree looking to the submissions being made, and we find some different mechanism in place.
That's right.
For the purpose of proper implementation and the fairness in the process. So we are at the root cause first.
I quite see that.
We are at the root cause first as to whether any mechanism in place is required in making a selection on the post in question, or we leave it to this your council of ministers and later on the prime minister and the final order by the president. You see all your act and rules. First is rule of business. Rule of business only describes which matter goes to which place.
That's right.
Nothing more, nothing less.
That's only deal the process.
Second is only laying down their service conditions.
Correct.
So the person, we are not on those. we are the stage how the mechanism in place for the purpose of appointment. After he is appointed, he will be governed by the Act of 91 laying down the service conditions. So we are not at that stage. Conditions are there. Now, see the data made available. Not one person after session has been permitted to have a 6 years of term. And if you're appointing the civil service officers, they retire at the age of 60. And by the time you consider them, to follow them, 2 years have passed.
Right.
So hardly get the time for one to put its vision and to make the system more better and acceptable. So something has to be drawn line somewhere.
I just let me as an attorney addressing the court, I'm sure I'm not a mere mouthpiece of the government. But at the same time, I must share to the extent the concerns have been raised. I may share them, and as an officer of the court at the highest level, so I'm only trying to share them. And I quite see what you're also putting to me that regardless of any other consideration, if several voices are spoken on this issue in different reports, there is something about say yes, why don't you look into this matter? But certainly it's important for the state to listen to it and see if something can be done. But why I am trying to go on this very lengthy exposition is that for instance, Vineet Narayan is repeatedly suggested, or Vishaka is repeatedly, invoked. In circumstances where they ought to be invoked, there can be no debate at all. And it must be done so. That's the best way of expounding the fundamental rights and freedoms of the Constitution. But when they are invoked in certain extended circumstances, and then sought as a precedent, said use this, and therefore I thought for the purpose of your lordships trying to look at it, it is very important to draw your attention to all that. I also looked at, for instance, the TN Session judgment.
That is Chief Information Commissioner also we have intervened. For appointment of a Chief Information Commissioner, this court has intervened in making
That is in the context of
in making a committee for the purpose of what judgment is there?
the secret judgment.
Chief Information Commissioner.
Yes,
Anjali Barbara.
yes, yes.
I'll
Anjali
just
Bharadwaj,
come to that.
I had mentioned
That is
that.
in the context of an actual appointment debate. Actual appointment debate. So therefore, concrete situations when the court may intervene, whether you have picked up a wrong person or a right person, have you acted for wrong consideration, that will be entirely different. We are on a doctrinaire situation. Therefore, to invoke those instances in a doctrinal situation when, for instance, we have in administrative law, we have several doctrines with like a common law growth. It has happened. Legitimate expectation, proportionality principle. They are doctrines with the court has evolved, and then they are well evolved and working well to ensure that the constitutional system functions on a fair basis. But therefore, these kind of instances where concrete situation, court will always interfere and say, I strike it down, I don't allow it. Now, if I was trying to look at the TN Session judgment, I'll currently come to that. Let's say if TN Session marks a little watershed in the whole electoral debates, both the person and the scheme. So I think important things have happened thereafter. Sometimes individuals make a difference in the scheme of things. Your lordship knows better. So I was looking at one of the arguments advanced is look at the other election commissioners, tenure and removal. They must be placed at the same position as the chief election commissioner. TN Session has looked at it. 5 judges bench has looked at it. I just get me TN Session.
Talking prior to session, nobody knew that there is some post like chief election commissioner. He was the only person who made known to the people at large in this country. If there is some post like chief election commissioner who has some power to see that the purity in election process must be upheld, which is the primary consideration to uphold the democracy.
We had other problems, but yet we not concerned it is.
Everyone has something, but let us see the positive side of the coin, the way the man has proceeded.
Well, the NOAA also throws some light on that, where it started with the notification, though notification was taken back, and the allegation against the Chief Election Commissioner by these two appointees that the post is deleted. So that's a question that's where it started with that. Then later on, when it came to MS Gill, and Justice Venkatachalaya in 2 paragraphs very clearly said that, and interestingly, when it was MS Gill, in my share of submissions, I make that. There also, a request was made considering that the election in Punjab was whether that was a opportunity of hearing to be given a debarred candidate or not. That was the question. And the larger issue was made and said that you should lay guidelines in that case, that there should be a natural justice in that. After considering entire scheme in 324(2) also, in the last paragraph, court says that it is good to, we don't want to embarrass the institution. It has gone down to that extent, say that we will not make guidelines on that part. So that is an examination and test given therein. But I'll make my submission, only one part. The statistics which my lords have given today to say that in last 7 years. So if we see that the trend in last 8 or 9 or 10 years, at the same time, 2 elections have taken place. And I have a stats of 2021 election. 912 million people were eligible to vote. 67% voted. And there is not even a single allegation, barring some small incidents, that the election is not fair and pure. There is a functioning of an institution which has functioned over a period of time. Well, a democracy is like a leaking pipe. You try to plug one hole, you need to see that it's going to be leaked somewhere else. So if we see, and this is there is a context in which I'm referring to in a multiple jurisdiction, this test is there. And there is enough reason why, if we look at the constitutional debate also on this, 3 options were given at the initial stage. One, to put it in the fundamental rights chapter, taken out. First suggestion came in the original shape, minus the subject to law provision which was there. At that time, the suggestion was made by Professor Saxena that so far as the appointment is concerned, let us leave it to a 2/3 majority of both the houses. Not agreed to. Second suggestion was that we come out with the instrument of instructions, like in US. That because US seems to be very onerous in terms of a time it's going to take, and sometimes we need these election commissioners to conduct election in a shorter period of time, and the parliament may not be in position to appoint and all that. So cut short formula was given that we come up with the instrument of instructions. What those instructions can be, when the parliament said that no, we don't want to come up with that instruction, or rather the framers said we don't want to come up, we are happy with this clause with being added subject to law. What it means, today those instructions can step in some other form by some other institution. That also is a question which requires consideration. I'll make my submission at that time.
Yes. It's here in this compilation. The same compilation. Volume 3. Okay.
Volume C. Volume C. Volume 3.
Escape. Before I read TN session, in the compilation volume 3, we have
Volume 3.
Indira
1509.
Nehru Gandhi volume
It is
3.
in 1509 volume.
Couple of paragraphs. Before I come to TN session, you Lordships may kindly turn to the Indira Nehru Gandhi judgment, which begins at page 1096.
Volume 3.
Volume 3. Just get me the 277. Page 1, 2, 4. I look. The concurring judgment of Justice Matthew at page 1243, paragraph 277. Like I keep in mind this very important question, what you said, that connection between the participation of an voter in the most free and fair manner possible, unbridled by any impediments, which may be in the nature of an election body being, not neutral and impartial, or any other consideration. Then look at if it is the reason of something which is unconnected with the electoral body not being neutral, then different considerations will follow. But if it's something to do with the other set of factors which may inhibit a voter from exercising her franchise in a free and fair manner, then different considerations will follow. Then the court may look into whether there is a law dealing with that, whether there is a failure under the law, and then who is responsible, and whether a law provides for a remedial measures in those aspects. All those considerations will be different. When we are talking about the electoral body, the election commission will not functioning in a neutral, impartial, or it has abdicated its functions and powers, leading to the disabilities imposed on a voter to participate in a free and fair manner, then the court will have to find out, has it really happened? And then how do we have tests to find out whether the connection between this and this is made out? There we have some very nebulous area. That's a very nebulous area. Unless concrete fact shows yes. I'll give you lordships probably later. I was looking at the position in a country like South Korea. South Korea.
Sorry?
South Korea.
South Korea.
South Korea. So there are several of the Asian countries where, like some of the European countries, post-Soviet collapse, new constitutional making, like Hungary and or Herzegovina, they're all very new constitutional frames have come in. Like the Constitution of South Africa, which had a very, the apartheid issue, and therefore you deal with it. For different constitutions have enacted certain provisions, keeping in mind the importance of moving forward. And then that's why somebody says, when you want to look at the future, don't look in the river mirror. But you must have a mirror ahead. That's right. That's what you're also putting to. For instance, in South Korea, we had the country had a problem of free and fair elections. The tussle between dominant political parties and smaller political parties, and therefore a competition in the political arena. How do you deal with that? And then questions of who should be entitled to vote. All those considerations have been considered and dealt with by the Constitutional Court of South Korea. Some they have said will intervene, some have said will not intervene. So it all depends, therefore, on a concrete situation. Then a law will come in and intervene and make things worse, or the law will not come in and make things equally worse. So those things are important for the court's intervention. So now let me write a few passages from Indira Gandhi, page 1243, paragraph 277. Will I have that pick? The Privy Council had occasion to consider this question in United Engineering Workers Union with Devanayak. I think it's better read the earlier paragraph so that it is understood. An election dispute at the public aspect is concerned more with the right of a constituency to be represented by a particular candidate. Does not follow from the public character of the controversy, there is no list between the parties to the election contest. The list can be resolved otherwise than by asserting the fact that the election and applying the 11th law. A judicial inquiry investigates, declares, and enforces liabilities as they stand on the present or past facts, and a law supposed already to exist. This is its purpose and end. Legislation, on the other hand, looks to the future and changes existing conditions, making new rule to be applied thereafter to all or some part of the subject to its power. The Privy Council had occasion to consider the question united so-and-so. The judgment of the majority was delivered by Lord Dillon, Lord Gus and so-and-so dissented. The question in the case was whether the President of a Labour Tribunal in Ceylon was a holder of a judicial office. If so, the man in question had not been appointed the way the Constitution of Ceylon required for appointment of judicial officers. whether the tribunal was without jurisdiction. It's clear from the judgment that lordship of the minority judicial power is the exercise of power on the basis of pre-existing law. The lordship said, another characteristic of judicial power is concerned with existing rights, that is, those which the parties actually have at the inception of the suit, and not those which it may be thought they ought to have. It is concerned with the past and the present and not with the future. Then turn over to paragraph 350. Let's hold it up. Was a very interesting paragraph at 347 on page 1260. 345? Yes. 1259, paragraph 345. I think the inhibition to destroy or damage the basic structure by an amendment of the Constitution flows from the limitation of the power of amendment in Article 368 read into by the majority in Bharati's case, because of their assumption that there is a certain fundamental feature in the Constitution, which its makers intended to remain there in perpetuity. But I do not find any inhibition so far as the power of Parliament or state legislature to pass laws concerned. 245 and 246 gives the power, also provide the limitation upon the power of the organs to pass laws. It is only the specific provisions enacted in the Constitution which could operate as a limitation upon that power. The preamble, though a part of the Constitution, neither a source of power nor limitation upon that power. Then skipping a few sentences thereafter, the line beginning, these specific provisions enacted in the Constitution alone can determine the basic structure of the Constitution is established. These specific provisions, either separately or in combination, determine the content of the great concepts that are in the preamble. Impossible to spin out any concrete concept of basic structure out of the gossamer concepts that are in the preamble. The specific provision of the Constitution is sub from the basic structure. So and so. Then the last line, the norms of elections set out by Parliament, state legislatures, tested in the light of the provision of the Constitution or necessary implication, therefore constitute the law of the land. That law cannot be subject to any other test, like the test of the free and fair elections in an ideal democracy. Then at page, para 346 in the next page, I do not think that an ordinary law can be declared invalid for the reason goes against the vague concepts of democracy, justice, political, economic, and social liberty of thought, belief, and expression, or equality of status and opportunity as some invisible radiation from them. That's where Professor Lawrence types invisible constitution concepts somewhere. We have some levels. I'll come to it a little later. Now, in the second part of the paragraph, they say definitions are important, but they're responsible in the last analysis for our image of democracy. Question is not only what does the word democracy mean, but also what is a thing. When we try to answer this letter query, we discover the thing does not correspond to the word. Although democracy as a precise literal meaning does not really help to understand what an actual democracy is. So then real world, so Dahl pointed out democracy is polyarchies. Now may skip all that, then come to para 347. Nor it can be tested on the touchstone of justice. The modern Pilate asks, what is justice, and stays not for an answer. That always reminds me of jesting Pilate. To Hans Kelsen, justice is an irrational ideal and regarded from the point of racial cognition. You think that only interest and hence conflict of interest, the solution according to him can be brought about by an order, satisfy one interest at the expense of the other, or seeks to achieve a compromise between opposing interests. Silence the concept of social justice is vague and indefinite. Liberty of thought, expression, belief, faith, and worship are not absolute concepts. They're emotive words. They mean different things to different people. The equality of state and opportunity of concepts laden with emotional overtone. In their absoluteness, they're incapable of actual realization. The enacting provision in the body of the Constitution alone gives concrete shape to the ideas. In the base of those provisions, the validity of the ordinary law should be tested. Then paragraph 340. Yeah, 349 and 350. This would indicate that the Constitution enters the task of framing a law relating to elections of Parliament, subject to the law to the state legislatures, an important branch of the law which stands in the area of free and fair election, namely delimitation of constituencies, allotment of seats, is put beyond the cognizance of the court. It's found the task of writing the legislation subject has been committed to Parliament and state legislatures of the Constitution. Is it competent for a court to test its validity on the basis of some vague norms of free and fair election? I think not. As I said, like other laws made by Parliament or state legislature, the laws made in the Article 327 and 320 are liable to be tested by Part 3 of the Constitution or any other provision of the Constitution. It is difficult to see how these laws could be challenged on the ground. They do not conform to some ideal notion of free and fair election to be evolved by the court from out of airy nothing. The doctrine of spirit of the Constitution is a slippery slope. The courts are not at liberty to declare an act void because their opinion is opposed to the spirit of democracy or republicanism supposed to pervade the Constitution but not expressed in words. The fundamental law has not limited either in terms or by necessary implication the general powers conferred upon the legislature. We cannot declare a limitation under the notion of having discovered some ideal norm of a free and fair election. Cooley has observed that courts had not liberty to declare statutes void because they appear to the minds of the judges to violate fundamental principles of republican government unless it will be found those principles are placed beyond legislative encroachment by the Constitution. Principles of democratic republicanism government are not set out as inflexible rules, and unless they are specifically incorporated in the Constitution, no law can be declared banned merely because the court thinks it is opposed some implication drawn from the concept. This is very important. Some implication drawn from the concept is what the court will probably very astute to avoid. And which 60. $460 at page number 1391297. This is Justice Bake's judgment. Then we have another judgment of Justice Bake, paragraph 460 at page 1297.
On what proposition?
No, on the proposition that whether court will take upon what electoral law should be. On that proposition, paragraph 460 at page 1297. The amendment appears to be within the unquestionable power of the Parliament to legislate either prospectively or retrospectively with regard to election matters. I've been able to see how it's capable of being interpreted as an attack on free and fair elections, which according to the learned counsel for the election petition is part of the basic structure of the Constitution. I think it's important to bear in mind that courts cannot take upon themselves the task of laying down what electoral law should be. The lawmakers assembled in Parliament assume to know and understand their business of making laws for the welfare and well-being of the mass of people in this country with the protection of democracy and a free and fair election. In accordance with the needs of the democratic process, better than postpone understanding. It's only where a piece of legislation clearly infringes the constitutional provision or indubitably overrides the constitutional purpose or a mandate or prohibition that courts can interfere. So and so, it will see the validity of the electoral. Paragraph 526. I
What
certainly,
what is the kind of line that you're trying to sort of adopt? What's your line of reasoning? What are you trying to tell us, like, in short? I'd like to have the drift of your argument.
Apart from requesting us not to interfere. What is-
I,
No, what is the route you're taking? We just like to know so that you're
I-
free to argue in your own way.
there are two things which came to mind, how to assist.
That's right.
One is to flag the concerns and how to flag a certain concern.
Yeah.
And how the court may look at it.
That's right.
That's it. Unless I do that,
You're
I
right.
don't think whatever else I may say may not fit in a context or may not be seen as
So from
relevant.
these paragraphs which you have referred to,
Yeah.
what is it that you're trying to tell us? What this court has held, so that we understand what your line of argument is. That democracy is part of the basic structure, settled law. All right. Now, this is an area where the state is, parliament has a discretion to make the law. We can't mandamus the parliament. We can't be obviously telling parliament to make a law. No, you're right. You're not going to do that. We can't do that.
Your lordship put it, I understand.
Yeah, we small area where we have some free play, in the joint, where we can contemplate, we can possibly interfere is to put in place a system which has been advocated right from 1990 onwards, which all political parties, in fact, Sri L.K. Advani in an article in the Hindu in the year 2012,
Yes.
he also pointed out. So all across the board, you hear voices, but they remain voices in the wilderness. They never get to occupy the center stage. So the reason is not far to see. The real crux of the matter is this. There is a fundamental right with the citizen. Democracy is a core value, basic structure, in fact, part of the basic structure. The situation on the ground is fairly alarming, which we pointed out to you with statistics. The most important part is this. There is going to be reluctance, obdurate, obstinacy on the part of the political party, whichever color we say, to let go of a situation or a position under which they can have a free hand, but not have a free and fair elections. So this is something which is self-serving. Basically, they will not like to get rid of the luxury in which they are ensconced. Because this is something which they can say, okay, Parliament, this is, as you are arguing now, it's only an enabling provision. The Parliament may make law. It's an enabling provision. So there is no law. We don't have to make a law. If you make a law, there is another aspect also, which is very important. If you make a law, it necessarily must be something different from the Council of Ministers telling.
That's right. That's right.
That's the point.
That's
So that is, you have to really move out of that comfort zone.
That's right.
Which suits you fine. Any political party. They would like to say, okay, let this continue, continue. After 100 years, this continue. So the point is, does the court say, sorry, hands off, we are helpless? Or do we say,
I quite see. I see. I'm not closing my mind or. But what is repeatedly coming to your mind is
how do we do
maybe
it?
Maybe it can be repetitive.
How do we do it? You are right there. You have to think carefully.
I put it very carefully. So the question is, but before the court will enter that stage, should we enter the stage of how do we do it? It will be the first question. So if we enter that stage, then several other considerations and questions will open up.
That is secondary.
That's right.
First,
But that's right. Therefore, the first question is, should the court
entry
enter
point bar, whether that should be maintained or there can be a side gate through which.
As officers assisting the court, we only sometimes try to rephrase a proposition and come back to it again in a more imaginative way if possible. I only try to do that to the best of my ability.
Your initial argument was that normally, if there's a lacuna in law without
That's right. That's
reaching the supplying of omissions, there can be interference, but if in the original text of the constitution,
Correct.
if certain things have been left to certain authorities, court should not interfere with that.
Right.
But here, what we are really examining is the manner of exercise of power by certain high organs of this state. So that manner of exercise of power under the constitution, possibly court can get into that and test. And in the event it's the manner of exercise of power is going on for a long period of time, contrary to what various expert bodies within the political system are recommending, then whether the no entry sign still operates.
Right.
And the sum and substance of the contention
Yeah, Lordship.
appears to be that the constitution thought it fit to leave it to the parliament, and therefore court shall not. It appears to be that.
Yes, in one way, it's because it is so. Because if the constitution, unlike a provision in a fundamental rights chapter, in a fundamental rights chapter, things are different. The court will always read meanings into a provision of a constitution because it's a living constitution. You must move ahead with the times and to ensure fundamental rights are realized. So that is an entirely different area of reading, meaning, more meaning, expansive reading, etc. But in any other part of the constitution, different considerations will arise.
And that is why we said, when you yourself thought that, of course, the constitution, it makes us, the parliament, obligatory to come up with a law. And again, some movement was there, but if you are not pushing forward for decades and decades, even then, can you still stick on this contention saying that even then the court shall not?
The question,
How long you can?
the question would there be? May not be the question of
Yeah,
what
you are
long,
right.
long may or may not necessarily enter unless the duration, a long duration, has shown complete aberration.
Because we are now taking
And
up this
complete-
after 70 years.
I understand. Complete aberration of the independence of the electoral body complete. If that aberration has
My lord, sir,
merely
we have clarified that we are not going to issue a mandamus upon the parliament to make a law. That would be beyond our
I
jurisdiction.
quite see that. Yeah. I'm only trying to say, because whenever you read an obligation under any law, I remember
That is
Under any law and under the constitution, it is.
Go back to
Therefore- therefore-
Bishop of Oxford.
right. Like when HLA Hart says, whenever there is law, there is an obligation to obey. That's how it is put, positive law. So, but question is, would the court say, I read there is an implicit obligation or there is an express obligation? The two things are different. If there's an express obligation, the court has no difficulty in declaring an obligation which you are breaching. But then when the court says there's an implicit obligation to proceed, because now you have, forget about what happened in 1950 and 59, 8 years, etc., well drawn out instances. We were in the process of understanding and comprehending our democratic group. The election process. In the first few elections, things how it worked. So one must go back in point of time, gather facts and to find out what made it necessary for some election officer to be there for 8 years or not. We don't have all those fact situations. So if those facts have been analyzed, and then you find there is now over a period of time, they all disappeared. 8 years was then necessary, now it is not necessary. 4 years was then necessary, now it is not necessary. So therefore, it all depends on the movement of facts, the developments, and so on and so forth, and an assessment be taken on them. We really do not have all those contours in this petition. We only have the reports. I can also say, for instance, the Prime Minister, you'll also refer to that report. So internally speaking, they know better what's happening, who is doing what not, etc. Therefore, one can again only do a second guess as to what persuaded any of these bodies to go and make a recommendation this should be done. That's a second guess. From the second guess, will the court say that I read there is an implicit obligation under 324(2) for you to make a law? I read an implicit obligation. I find there is some difficulty about it. That's all I'm trying to point out. If it is an express obligation, nobody can contest it. So the obligation again in respect of what is the question? If you read Article 324(2), the president is the appointing authority. Now, will the court say the president will not be the appointing authority? The court will not say that. Then the president is consulted under Article 74. Now, that consultation process. Next question is, if there has been an aberration in the consultation process or there's an abuse in the consultation process, which is demonstrated by all these facts over a period of time, then comes the question.
That is the area possibly where we can enter as per established principles of political science.
What's called the interstitial legislation. But even there, I want to only add some caution that you'll also look at it.
No, we are aware of that, and we can anticipate on the points on which you will caution us.
I cannot a lot of wisdom on that. I'm trying to share this at a certain level.
We'll come back.
Very